So in this segment, we're going to be talking about a High Court judge ordering Matt Hancock to hand over texts and WhatsApp messages about a lucrative COVID-19 contract. So the Good Law Project have been taking predominantly DHSC to court over certain things, and one of those is predominantly how COVID-19 contracts were handed out. And so Matt Hancock has gotten into a fair bit of, I'm not going to say trouble, because although some of his actions were illegal, it wasn't. I think he can get away with those ones, in terms of the in the court of the people's opinion, because he's managed to spin it as, oh well, we were so busy giving out contracts to people, to certain companies that what happened was that I couldn't publish the contracts because I was very busy and my department were working all week, and they didn't have any breaks, and that's why we couldn't publish the contracts and we broke the law. If we actually look at the article, which is that the government used an exclusive WhatsApp group to give VIP company CEOs information about its PPE requirements. So the questions we need to ask are: how do you become a VIP? How do you get into this WhatsApp chat? Did Matt Hancock, was this chat being monitored by anyone, which I believe is the rules under the ministerial code, that if any government ministers talk business, there has to be someone present, or they have to relay that information back to the cabinet secretary or somebody, a civil servant, etc. There are specific people mentioned, I just can't remember who they are meant to be. But did he do that? Or has he not done that? Because if he hasn't, that means he might have broken the ministerial code, which is meant to be a resignable offence, but who cares about resigning when you can just ride out storms? So a High Court judge ordered Matt Hancock to hand over texts and WhatsApp messages about lucrative COVID-19 contracts. The Good Law Project, who has been pursuing the government in the High Court to reveal details of the VIP fast lane for COVID contracts. So the Good Law Project, I think, are trying to figure out which contracts were handed out to who via this VIP fast lane. Evidence brought up today suggests the government used a WhatsApp group of 200 CEOs to provide special communications, apparently unavailable to other suppliers. So if you're a company that's manufactured or sourced PPE, and the government, you're offering a good rate and you offered good product, legal product, and the government said no to you, and they went with one of these other dodgy companies because they were in the VIP WhatsApp chat, you've got to ask yourself, is that fair? Was that right for the government to do, to go to these other companies in the VIP lane who the government we know overpaid for these products? Was that a moral and right thing to do with taxpayers' money? The existence of the group was revealed for the first time today in a meeting agenda from last April disclosed to the court by the government. It reads, redacted to connect with redacted and confirm preferred way to sharing communications with CEOs and CPOs, Chief Product Officers. So what we can tell is, for whatever reason, WhatsApp was the preferred method of communicating with these CEOs. And how much of this stuff can be gotten through Freedom of Information Acts, I don't know, because I think WhatsApp chats and private messages like this aren't really covered under Freedom of Information Acts. But what we can gather is it's a big old club and you ain't in it, because if you're a company offering services, offering PPE that the government desperately needed because we ran out at one point last year. If you're one of those companies that offered services like we mentioned before, where the PPE was eventually exported into the EU because the government didn't want to buy it because they had other places to buy it from, I would be pretty annoyed if I was one of you guys right now, and I would ask your local MP, why was it that my company was disregarded but these VIP fastlane companies were allowed when some of them didn't offer product that was even legal to be used in the UK? Ask yourselves. No, there is a WhatsApp group with 200 CEOs, and this is informal way to communicate. There is also a separate channel for CPOs, for Chief Product Officer. So it looks like there were two big group WhatsApp groups. I didn't even know you can have 200 people in a WhatsApp group. The second group included purchasing officers for the firm. So it's very clear that something dodgy happened here. It's very clear, and we just got to hope the Good Law Project can figure it out, because if it's the case that they gave preferential contracts, so someone could directly contact Matt Hancock instead of going through competitive tendering or any kind of competition, shows you how dodgy it is, especially as it's done through WhatsApp. That means people have your personal phone number. That's what that means. Like, how are you so comfortable with these CEOs that they have your personal phone number? It's embarrassing. Government lawyers so far have failed to disclose any text or instant messages to the court. So if they are not careful, they may be held in contempt of court for not following the court's orders. Today, the court ordered Matt Hancock to search for and disclose text and WhatsApp messages for some selected civil servants. So by the looks of this article, it's not just Matt Hancock who has to hand out the text messages, but it's also certain civil servants as well. The government was also ordered to pay the Good Law Project's legal costs, which is more taxpayers' money being spent because Matt Hancock wouldn't do the right thing and actually give out these contracts properly with competitive tender. No, he decided he didn't want to do that. He's not about that life. And that's why more taxpayers' money is going to be spent on funding the Good Law Project's legal costs because Matt Hancock decided to mess around and find out. So Jason Coppell, works for the Good Law Project by the looks of things, said there's an obvious lack of transparency in Hancock's conduct. The defendant has made late and only partial disclosures and has refused to provide critical information on parts of the case against him. I think that's clear with the redacted connected to redacted bit earlier. So what can we tell from this is the fact that the government, released these text messages late because then it makes it more difficult for the Good Law Project to mount a proper offence because they need time to go through the messages. The claimant has been left in a position of being unable to interrogate and fairly challenge the account given by the defendant. So that's saying that the Good Law Project have been put in a position where they can't fully interrogate and fairly challenge the DHSC because of the fact that the government had decided to release the text messages late and often left some of them redacted, which meant that you can't actually fully join the dots because some of the dots are covered by something. He said there's been an obvious lack of transparency in the conduct of the defendant. So Michael Bosher, this is Matt Hancock's legal representative, he said the Good Law Project wanted to expand the scope of a disclosure exercise in fish. So what he's accusing them of is a fishing expedition. And so what a fishing expedition is, you widen the scope as much as you can and you're just looking around for anything you can grab onto. That's what a fishing expedition typically means. Having objected extensively and at length about the nature, this is the lawyer for Matt Hancock, saying that about the nature, scale and cost of the defendant's disclosure exercise, the claimant now seek on highly spurious basis to materially expand the scope of the disclosure exercise. So what he's saying is that the Good Law Project haven't got much, so what they're trying to do is expand the scope of the kind of prosecution, so that way they have more leeway to get away with certain things that they want to accuse the government of, which is a really weak legal defense, to be honest with you, because typically if you're ordered to pay out someone's legal costs, it means that your side lost. So this guy's argument's really weak. This guy goes on to say, in doing so, they seek to significantly increase the costs incurred by the defendant in order to fish for additional material and risk derailing the trial timetable, or your client could actually disclose the messages in a timely manner and stop redacting them. How about that? The court has heard last week that civil servants had complained they were drowning in requests for companies with links to politicians and senior officials wanting to jump the queue for lucrative PP contracts. So civil servants have basically said that there's so many people, we saw 200 CEOs and there were more of the purchasing officers who wanted to jump the queue. Essentially, they wanted their company to get a contract, which makes sense because they're there to maximize profits. That's what your CEO is there to do. But because there were so many of these companies in this VIP lane, which we still don't know how they actually got in the VIP lane. We don't actually know how they got in the VIP lane, but what we do know is that it's very, very strange what's happened here, and it doesn't look great for DHSC. So government staff warned that the fast-tracking firms had a knock-on effect on the remaining offers for help, according to emails revealed in court. So what they're saying is that by having to help the VIP companies, it meant that the civil servants and whoever else was helping to deal with bids had less time to look at the non-VIP contracts or applicants. And so the question you need to ask yourself is, were you a part of this VIP lane? Were you offering the government contracts, bidding for contracts that the government turned you down on, despite the fact that we struggled so much, specifically during the first wave? Because I'll tell you for free, it's a big old club and you ain't in it. That's a quote from the great man George Carlin. Because if it's the case that these people in the VIP lane, they got a contract ahead of you simply because they were in the VIP lane, it tells you that it's a big old club and you ain't in it. Anyways, let's keep an eye on what's going on with the Good Law Project. Hopefully they keep winning cases against the government and more information gets revealed. Anyways, I'm going to leave it there. Let me know what you think in the comments below. Like, comment, share, subscribe, and hopefully I'll see you in the next one.